case briefs, and so much more. LSData's got what you're looking for.
In a 1948 case, Friedman v. Delaney, the United States Court of Appeals for the First Circuit, examined whether a lawyer could claim a deductible loss for a payment made voluntarily, which resulted in a loss. The lawsuit began when Mr. Friedman, a lawyer, deposited $7,000 in court for a client's proposed bankruptcy, and the commissioner refused to allow the deduction of $5,000 claimed as a bad debt in his tax return. The dispute centered around whether the payment could be considered a deductible business expense or a loss incurred in business. Mr. Friedman argued that the payment was an obligation in keeping his professional word, as he had assured attorneys for the creditors that the money would be forthcoming, even though his client, Mr. Wax, would not be legally liable to pay. Although the lower court denied the plaintiff's claim for the item of $3,411.47, the Court of Appeals ruled that the plaintiff was entitled to a $235.19 tax refund for 1941. However, the district court's decision to deny the deduction of the $5,000 as an expense or a loss was affirmed, as the court found that the circumstances did not meet the criteria for either an ordinary and necessary expense of his business or a loss incurred in business. The judgment of the district court was vacated, and the case returned with instructions to enter judgment for the plaintiff in the amount of $235.19 with costs.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.